to 3%. I crossed out as long as the host community agreements are truly related to 3% and replaced it with assuming that the community impact fee is truly a list of related costs rather than a 3% fee without documented costs. Bottom of that page, Commissioner Title thought the commission should reevaluate what is happening today with the host community agreements. I changed that to Commissioner Title thought the commission should reevaluate its previous decision based on what we know is happening today with the host community agreements. Next sentence, Commissioner Title says she believes the vast majority of municipalities are acting in good faith. However, there are some that are going beyond the guidance. I changed that to going beyond the law as laid out in the guidance. Next page, Commissioner Title noted that the timing is important now because the commission have not issued a final license. I changed that to the commission has not issued a final license and thus we can treat all current and future applicants consistently. And then at the end of that paragraph, after Chairman Hoffman would like to get more data, but also shining a light on these agreements may encourage people to change their behavior, I added a sentence, Commissioner Title said she believes the information and evidence is already out there and that a light is already being shown. Next paragraph, Commissioner Title said that on the issue of penalizing the applicants, this is one area of the law the applicant has to be in compliance with. I changed that to this is one of many areas of the law the applicant has to be in compliance with. Next page. Commissioner Title said the commission has a research agenda and should be able to include it in our guidance. I changed that to and should be able to include a summary of current research findings in its guidance. Commissioner McBride suggested changing the word discouraged to necessary. I changed that to Commissioner McBride suggested changing the word discouraged to encouraged to carefully consider whether necessary. And that's it.
I'm going to just make a suggestion if I could.
Yeah.
Can we defer this to next week? Because there's a lot here. I think they're all important. I have not had a chance to review them, nor has I believe the rest of the commission.
I'm sorry, I
and
didn't
rather,
even know you
I think
suggested
that there's more. I think there's enough here that warrants us all having the opportunity to review it. And so if I can suggest, and unless anybody objects, let's just push this off to next week's next meeting's agenda. And Mr. Executive Director can make sure that it's circulated to the commission. So absolutely. Thank you. Is that all right with everybody?
Yeah.
All right, thanks. You missed a really important conversation about minutes, so. Let me know if I'll pause with you.
Thank you.
Thank you. Okay, so we'll get to the minutes at our next meeting. So that brings us to the Executive Director's report, starting with introduction of our new staff member. My apologies for not recognizing you in the sea of people out there, but Mr. Executive Director, if you would introduce our new staff member, please.
Of course, thank you, Mr. Chairman. As usual, I'd like to, introduce our newest team member, Samantha Doonan. Samantha joins the commission as our research analyst under Dr. Julie Johnson's team as our research director. She is a graduate of Brandeis University, and most recently she served as a health science specialist at the Veterans Affairs Hospital. So that she joins Julie Johnson's team to help us with our research agenda and really serving as an analyst for a lot of the data that we will be collecting as well as gathering from other sources. So I'm very excited to have her on board.
Welcome on board, Samantha. It's great to have you. Thank you, Mr. Executive Director. Other staffing items?
There is one description I've placed before you for your consideration. This is a unique role in that it is not an FTE, so to speak, as far as joining the commission's ranks. It's more of a contract position. This is for the role of the hearing officer. The hearing officer would fall into the legal department, reporting to the general counsel. Again, it's a contract position, given that we don't know the need from an ongoing day-to-day basis, but it's an important role in our administrative process in the event that there is any rationale or any reason that would be triggered from a review standpoint. So there would be a not employee of the commission, but a role that we would oversee and manage in our administrative process. So happy to take any questions you may have or any feedback you might add.
Are there questions or comments on this job description? Commissioner Tom?
I'm just curious about the limitations on their other work. Would they be able to hold other jobs too?
Certainly other jobs or perhaps even serve as a hearing officer for other agencies. I think that's more commonplace, is that they may be a retiree or a retired judge, for instance. But there would be obviously a conflict that we would monitor or want to see. But by and large, this role may be a hearing officer or a contract hearing officer for other agencies or other departments. Would be the most common circumstance. But the objective here is really to put this out and see what we get for responses as well.
Other questions? When would this be posted?
I think.
Are you gonna wait, or?
Not wait necessarily, but I don't think it's not gonna be posted today. I guess it'll be posted in due course, probably in the next few weeks, just to identify a pool of candidates and give Christine and her team a chance to review them. But not anticipating today. It's not an urgent need necessarily, but it is time sensitive in that we are in the licensing phase, so don't want to wait too long.
Okay. Great. Thank you. If there are no comments, let's move on to the next.
And it would need to be
Oh, yeah.
approved. We need to be approved as a
Needs to be
position.
approved, okay, that's fine, thank you. So, can I have a motion to approve that job description and the ultimate posting of it? I'm sorry, I missed it. So, Commissioner McBride made the motion to approve, seconded by Commissioner Flanagan, all in favor?
Aye.
Let the record show the commission unanimously approved that job description. Thank you, Mr. Executive Director. Any other staffing issues before moving to the licensing status?
No. So the usual slides are before you for your consideration, starting first with say, for instance, a 30,000-foot view of our application portal. There were 2,431 applications. 248 of those have been submitted with at least one packet having been submitted to the commission. 129 have been withdrawn, and there are 2,035 that are incomplete and therefore not yet submitted. There have been 19 provisional licenses issued, and they break down to the following categories: 2 craft cooperatives, 4 independent testing lab, 2 laboratory agent, 53 cultivation, 74 establishment agent, 9 micro business, 31 product manufacturer, 3 research, 61 retail, 3 transportation with an existing establishment license, and 7 third-party transportation licenses or applications, totaling the 248 that are pending with at least one packet. The next is more of a what does the workload look like review, which is there are 112 applications that are pending with all 4 packets having been submitted. Those include testing labs of independent testing labs being 3, marijuana cultivator is 39, micro business has 3, 29 product manufacturer, 29 product manufacturer, 3 research facility, 33 retail, and 2 transportation with an existing marijuana establishment license. That gets you the 112. That is a difference of 17 from the last meeting, and that breakdown, as you can see, there are 69 that have secured priority status as an existing RMD, 3 that are economic empowerment priority, and 40 general applicants. And those 112 applications represent 60 different or separate entities.
Any questions?
So as you will recall, we developed this slide as I think a chance to review where those 112 stand as far as process. And 27 have been submitted and awaiting our review. That of course includes those 17 that have come in during the course of the last 2 weeks. 34 have been deemed to be incomplete and therefore require additional information. 27 have been deemed complete, and we've begun our third-party external review between our background check vendor as well as the notice to the municipality for certification of compliance with local ordinances and bylaws. There are 5 that are before you today for your consideration, and of course, the commission has considered already 19 applications. That is how those 112 break down.
Questions? The map?
And lastly is the map and how that breaks down between counties throughout Massachusetts. And the difference, I think, is probably the most important part, which is that in Berkshire County, there's 1 additional application from the last meeting. Hamden is 2 additional, Hampshire County is 2 additional, Worcester County is 5 additional, Middlesex County is 2 additional, Essex County 1 additional, Bristol County 1 additional, and Plymouth County with 3 additional. And that's, again, as you can see how they break down across Massachusetts.
Thank you. Is there anything else from the licensing update?
There is not other, or perhaps before going into the medical
Yes.
marijuana update, just a few things I'd like to update the commission on from just a pure notice standpoint. As you know, we have the RFQ has been issued for the social equity program.
Mm-hmm.
Questions for that are due by the commission to be posted on our website today, and that's our hope, is to be able to post that today. Again, that RFQ does close on September 7th as far as responses are concerned. Previously, the commission issued an RFP for open data or an open data solution. My hope is to be able to come back at the next meeting with a recommendation on that. We've been busy evaluating responses. Lastly, the Energy and Environment Subcommittee met this week. Last week, the Citizen Review Committee met, and next week, our hope is that the Cannabis Advisory Board will be meeting. So a lot of activity otherwise that's been going on around the commission. I just want to make sure the commission was aware of that.
Thank you. Appreciate the energy and effort behind that. Are there any questions? Let me just make an introductory comment to the next section, which is to talk about the timeline for the transition of regulatory responsibility for medical marijuana from the Department of Public Health to the Cannabis Control Commission. I want to first of all acknowledge that there's been a lot of work been going on for several months on this, led from our side primarily by the executive director and by our chief of staff, Eric Isabelli. And I just want to acknowledge and appreciate that. It is hard work. Two is that the work primarily has involved a series of working sessions with people from the Department of Public Health, and perhaps as you go through this, Mr. Executive Director, you can just recognize some of the specific names that you've been working with at DPH, but I just wanted to acknowledge that DPH has been our active partner and collaborator in this process, and we appreciate that, because there are a lot of moving parts here as the Executive Director is about to go through. Third is the timeline that the Executive Director is going to show us right now is essentially the regulatory timeline in terms of what we need to do to get final regulations in place so that we meet our legislative mandate of having this transition occur before the end of the calendar year. There are a lot of other things that have to happen as well with respect to employees, with respect to contracts, and I've asked the Executive Director, while they're not mentioned on the timeline, to at least give a perspective on the other activities besides regulatory that are involved in the transition. So I appreciate it if you do that. And then the last comment I want to make before turning it over to the Executive Director is we are going to hit the legislative mandate here. There is no question in my mind that we are committed to that, and that the process that we're working will accomplish that objective. So it's a complicated process. As I said, it's one of many challenges that we have on our plate, but there's no uncertainty in my mind that we will hit the legislative mandate in terms of the timing of this transition. With that, Mr. Executive Director, if you walk us through the timeline.
Sure. Thank you, Mr. Chairman. As you indicated, we do have a good and reliable partner in the Department of Public Health in this transition, and we've really been the beneficiary of their expertise in this, frankly, this policy area overall, not just medical, but as we embark on the adult use side of things as well. So we've been very grateful for their support and their cooperation in this. This step here, as far as the development and promulgation and adoption of regulations, is strictly a commission function. It is something that they, of course, would simultaneously or in a similar fashion have to rescind regulations in order to effectuate that transfer. But this is this timeline that's before you now for consideration and discussion is really our step in adopting regulations. So given the regulatory timeline that we are up against, in order to effectuate a transfer by the end of this calendar year as statutorily required, we would need to begin in earnest as we have many months ago, and in fact we did. I previously updated the commission with an interim report that was due to the legislature, so there was some level of review at that point. But in order to effectuate that time frame of what would really result in a December filing of regulations, my hope would be able to bring draft regulations relative to the medical use of marijuana before the commission by September 6th, which would be our next scheduled meeting. That would also open up the public comment period as previously, as the commission previously considered the adult use regulations. There was a robust public comment period related to that as well. That would require folks to submit comments or testimony or feedback on those regulations to us, and we'll be able to accommodate that both in a formal way of folks sending us letters or mail, as well as any email comments that may come in as well. We'll make sure we can accommodate all of that. Related to the public comment period is also the need to host a public hearing, at least one, and this stipulates more than one, perhaps in Boston as well as in another location, in order to accommodate any public feedback. And at that point of the public hearing, our intention would be for the public comment period to formally close in order to allow us to develop and compile all those comments and provide them to the commission for your evaluation and review. That would occur, that public discussion or public review of any feedback and discussion of any modifications that may be proposed to regulations would be scheduled for November 1st, which is another regularly scheduled meeting of the commission. And then finally, based on those comments, be able to bring back a final draft of regulations for formal promulgation on or before that November 30th timeframe, thus allowing us to file them in accordance with a December deadline to be published and formally promulgated. As you indicated, that this is obviously a powerful timeline that will dictate and manage the transfer. There's other elements of it.
I would ask
Sure.
you, before you get into those other
Of course.
elements, which I'd very much like you to cover, are there any concerns or questions about the regulatory timeline from the commission? Commissioner Todd?
So if the public comment period closes on the 29th, that doesn't give us very long until the discussion. Is it possible for us to get or to be able to access the comments all along so we can keep up with them?
I think we can absolutely accommodate that. Yeah, that's a great point. And I think similar to how we've managed public comments in the past, I think we can certainly make, as we collect them, we'll be organizing them and kind of organize or compile them on an ongoing basis. So it's not a last minute rush to do so. And that's something that we can certainly, I guess, maintain in some sort of central repository. But I guess the November 1st is more of a chance for the commission to formally discuss them publicly, as opposed to get them on the 29th in order to facilitate a conversation. But we can certainly maintain them in an area that folks can access.
Great.
And then one other question. So what's the process for developing the draft?
Again, I think it's largely been working with the Department of Public Health to understand their existing regulations. And we've looked at really facilitating the transfer is to, I guess, assume the program as it exists today, and largely looking through their regulations to compile them and format them for our regulations. So I guess from a scope or a spirit standpoint, it would largely be what exists today with very few modifications, but I think that's when obviously the commission would have the opportunity to put your stamp on it as well. But developing them, it's really been working pretty collaboratively with the Department of Public Health.
Just kind of piggybacking a little bit on that, given that this will be reviewed on September 6th at our next meeting 2 weeks from today, when do you think the commission will have a copy of the draft to start looking at prior to the meeting? As much lead time, obviously, as possible would be appreciated.
I think that's the objective, is as much lead time as humanly possible, also making sure that what you get is a version that is ready for your consideration as well.
So do you have any estimate when that might be? Well, I promise I won't hold you to it, but just...
Oh, well, in that case. No, my hope is we're early next week.
Great. Are there other questions or comments or concerns? Once again, my thanks to Sean and the staff, our general counsel, I know who's been driving this, so thank you.
Sure.
This is a very thoughtful process. It's got a lot obviously embedded under the words. But now, if you wouldn't mind talking about the other elements to transition.
And I think the transferring a program in a program the scope of which the medical use of marijuana program is, to your earlier point, is not an easy task, and something that we've been talking through with the Department of Public Health for quite some time now. What's not lost on me as well is that there's folks that work in this program and have really put their fingerprints on the program as it exists today and as it's evolved over time. So how we manage that personnel transfer is really critical to me, and making sure that we're as thoughtful and as considerate as we can be. Of course, related to that is there's several collective bargaining units that are part of that, and working through logistics there. There are several contracts that the program maintains, and we want to make sure we can transfer those strategically. In some cases, as you may recall, we have the same background check vendors, so thinking through logics of that is that something that we can assume in our contract, or we have to adopt a new one? We're working through a lot of issues like that. So that's one piece. Space for employees is another issue that we're working through. We've worked, and I also want to acknowledge that this has been a commission-wide lift. Each relevant department head that we have brought on board has really integrated pretty seamlessly into a lot of these conversations in their respective roles. So there's also a transfer of the medical marijuana trust fund that gets deposited into the marijuana regulation fund, so our CFO has been pretty intimately involved in that. Also, the comptroller's office has been helping us as far as navigating the logistics related to that. Christine Bailey has really wrestled with the contracts and tried to understand how best to accommodate those transfers. Erica White, our chief people officer, looking at it through a personnel standpoint, and of course Erica Chiavelli has really spearheaded since her arrival that kind of global conversation. So this has really been a very broad commission lift, and something that we're very mindful of. Also, lastly, is an IT related function of there's a patient registration portal that is managed through the virtual gateway. DPH being a subsidiary of HHS, there's a lot of not so much complexities, but layers to that we also need to unravel, and making sure we're able to accommodate that. Similarly, I mentioned earlier the employee element, wanting to be thoughtful and considerate. There's also patients that we want to make sure that process is seamless as well, but also that data is really protected in a sacred way to make sure there's no risk of breach or anything like that. So I think we've tried to tackle this as thoughtfully as possible, but to your point, we are very mindful of the legislatively mandated deadline, and at this point very confident they're able to meet that, and using that, also building ourselves hopefully enough of a cushion to identify that there's got to be something out there that we may not have thought of, or that will just be one of those last minute wrinkles that we're able to budget time accordingly and be thoughtful about that as well. So also you mentioned if I could just identify some folks at DPH that we've worked very closely with, although he's no longer with the program. Brian Harder as their director has been a valuable asset. Jen Burrell in the commissioner's office, Karen Van Unen as a contractor, Joe Nicholson as the director of compliance, Jenny Nathans who manages their application process, Karen Geegan who oversees as their deputy director, but also the patient support center. All have been real valuable assets for us. Again, not just in the context of the medical marijuana transfer, but really as we develop our own program here internally. So could not be more grateful for their support.
Great, thank you. Other questions? Thank you. There's so much on our plate, and I've always been concerned about finding the right balance between hitting the regulatory requirements in terms of the transition and not putting too much on our plate while we're trying to stand up the adult use program. So I recognize the workload and the burden, and I appreciate the effort of you and the others to make sure we hit that deadline. So thank you.
Sure.
Anything else in your report?
No.
Okay.
Thank you.
Sure. The next order of business then, if I'm correct, is to talk about host community agreements and pick up the conversation that we started at our last meeting 2 weeks ago. Let me just try to kind of set the table in terms of where we were and what I think we would do today. This is an important topic. It's clearly a timely topic. I think we've all at some point in time said that it's important it should resolve quickly so that we don't have the current set of licensed applicants being dealt with one way and a future set being dealt with another way. We have to be consistent. So it's a very timely and important topic to get resolved. Commissioner Title made a proposal on this at our last meeting, which I'm going to ask you in 2 seconds to review, if that's okay, just to get us all fresh. I made a alternative proposal that I'll also review. But before we do that, and then after we do the review, then we can have a dialogue. But before we do that, we left last meeting agreeing to come back to this in 2 weeks, and asked in the interim that the executive director answer a very specific question, which is if, and I can't emphasize the word if enough, if we were to review the host community agreements as part of our final licensing process and require that applicants make those available to us and perform a review of those. The question on the table was, could we do it? How would we do it? How much time would it take? How much staff resource would it consume to do it? And that's the explicit question we asked for the executive director to come back to us with today. And he's about to do so, but we also, it was a narrow request because if we were, and again, I can't emphasize the word if enough, if we were to review these as part of our final licensing process, it is not just the staff work to do the analysis of these agreements, and it is then the commission to discuss what, if anything, we need to do based upon the staff analysis. And if we decide there is further action, what does that mean in terms of staff time and elapsed time? So the specific answer or specific data that the executive director is going to share with us now is only on that first piece, which is what does it take, can we do it, and how much time and resource would it consume to do a review of the host community agreement as part of our final licensing process. So with that, I'd like the executive director to kind of share what you've come up with.
Sure, thank you, Mr. Chairman. So to answer that question, I convened kind of a group of folks and tried to think through logistically, but also to your point at a pretty high level, our ability to, during the course of an inspection, extract this information and what that would look like. And related to that is how we would even prepare to do that. So as you know, the commission will have a team of investigators and inspectors that will be visiting facilities and inspecting them in the course of the intervening time between a provisional license and a final license. If the question were, or the requirement were that we would extract information relative to a host community agreement, that would require, and by and large, and I guess I'm painting a broad brush of the role of an investigator, there's a likelihood or a good chance they are not attorneys. So we would have to train these folks and I guess some spoiler alert, there's a good chance they're not attorneys.
And I'll withhold any comments that I might make on that.
Appreciate it. So that said, we would need to train them as far as reviewing the contents of a contract, or I guess the four corners of a contract. By and large, my understanding, and based on some review, that these are not massive documents, so that from a time frame standpoint, we would estimate that it would take just about an hour, but that would vary depending on the contents of the actual contract itself. But given the volume of agreements that we were able to review, it does not appear as though they're large in size necessarily. Therefore, we would estimate that it would take about an hour, and that's also factoring in the fact that they are not attorneys that would not be specialized in necessarily evaluating contracts. Instead, their task would be to extract information, thus allowing the commission to evaluate those contents. So the first step would be to train the inspectors, the investigators, in what to look for and what to extract. Also, formally behind the scenes, which is why it's not necessarily included here, is developing that as part of our inspectional protocol and a checklist that is under development today. So incorporating that and ensuring that we can extract it. The next step would actually be to inspect each facility or each entity, and during the course of that inspection, seek the document, review the document, and extract that information. And lastly would be to, after extraction, compiling that as part of an inspectional report that we would then give to the commission during the course of a final license, and that deliberation or that consideration of a final license, and making sure that you have the information you need in order to evaluate the contents of that host community agreement. So instead, the question or the charge to the investigator would be to extract the information as opposed to evaluating its contents itself.
Thank you. Are there questions or comments before we start the rest of the conversation? Commissioner Flanagan.
Thank you, Mr. Chairman. I have a couple of basic questions. Based on what you said, Mr. Executive Director, who is providing the training to our inspectors? And subsequently, is there an actual training program? You know, we all have different things that people are trained in. Is there a training program that's going to be used, or is it strictly going to be something that we have to create?
Sure, so my approach at this point, obviously given both the time consideration of procuring some sort of training, and also I will admit I'm not aware of any training that would be available specifically, of course, on host community agreements, but the training itself would be developed by certainly myself. I would ask our general counsel and our chief of investigations, or director of investigations, to develop some sort of protocol. It would not be my intention to seek any sort of outside vendor or anything like that. So that would be a request of myself and kind of senior staff in order to make sure they're adequately trained.
And my other question is, when it comes to extracting critical information, what is, and I know this is going to be wordsmithing, but what's going to be considered critical? Because I know that today we're talking about 3% and we're talking about impact fees. Tomorrow it could be something else. You know, my concern not only is the fact that we have two entities entering into an agreement, and it should be that way, but what information are we looking to extract for our purposes,
and how are we gonna use that?
Sure, so the intent, and I would also look to the commission for some direction here, but the intent would be to extract that information that would need to be evaluated from a compliance standpoint, including, I think it was discussed at the last meeting 2 weeks ago, kind of those 4 elements, including the term of the contract, the fact that all requirements are stipulated as part of that contract, and then the community impact fee relating to 3%. So those would be the critical elements that we would seek to extract. In context, I think is important here, which is it, again, just based on review, it's not always as clean as 3% or a flat fee. There's kind of throughout the contract would be delineated certain obligations or expenses or payments, and I think we would seek to pull all of that information. So it's not, again, picking what a certain field or looking for a certain clause. It would be pulling it a complete review of those elements to give the commission as much information as possible.
And then, Mr. Chairman, one last question I
Sure.
have is that when we talk about the inspectors that are gonna be trained, with regards to reviewing the HCA's, and you clearly stated that these inspectors may or probably will not be attorneys, and as one of the only non-attorneys on this commission,
Please.
are they going to have legal backup? Because I guess one of my big thoughts in my head is that when we get sued, we go to court, which is ultimately going to happen at some point in time. What legal backup are we going to have? What legal reasoning are we going to have for the information that has been taken from the HCA's by people who are not attorneys?
Sure, so it's our hope, structurally, of course, and I'm grateful for the commission's support in developing the role of an enforcement counsel that would report to the Chief of Investigations and Enforcement and really be there to advise and support investigators in the course of their work. Now that, of course, includes routine inspections and developing inspection reports that would also fit in context in this capacity as well. And of course, the commission does enjoy the benefit of Christine Bailey's role as general counsel. So I'm from a legal backup, from a day-to-day activity standpoint, I'm very confident in our ability to be in our operational elements and pretty sound footing. But again, my intention in the course of this developing this process here was to give the commission information that you would use to evaluate the contents of that agreement.
Thank you very much. Thank you, Mr. Chairman.
Sure, and if I could ask, the request to the executive director, which I appreciate your follow-through on, was just how to do this, not whether we should do it or not, and that to me is the rest of the conversation, is whether we should do it or not. But I appreciate the work of the executive director, at least giving us a sense of what would be involved and what would be required. And I presume that whatever, if we do, again, I keep saying it, but if we do, the commission would obviously have the final say on what exact information we would like to see extracted from these agreements. So we'll have a chance, if we go that route, we'll have a chance to do that. But let's not talk about whether, let's just, any questions on the facts or of the process that the executive director proposed, or the time or resources required to do that? Commissioner McBride?
So it's my understanding that we would be provided with the information and that we as a commission would be evaluating it. How? I'll put out there, I'm not a municipal finance expert. I don't have knowledge of all 351 cities and towns and what individual needs are, and what information in addition, if any, to what is being extracted as part of the contract will we be receiving in order to evaluate the information that's for us, or is it just the four corners of the document?
From a report standpoint, it would be the contents of that agreement. And then in developing that inspectional report would be other findings that may come during the course of the inspection as well. But I guess the question is how you would evaluate that. I guess
We didn't ask the executive director to answer that question.
Okay.
If you have a perspective, I'm certainly, I was trying to jump the hook. But if you do have a perspective on that, I wasn't trying to cut you off. I just was trying to make it clear that we did not ask you to answer that question. So if you haven't an answer, that's fine.
Sure, I mean, I guess and briefly, that would be that, I guess you would, whether it be call upon experience, or evaluate the terms that are provided in the context of the inspectional report, again, within the four corners of that contract.
Commissioner, go ahead.
Sure, and so just to make sure I'm understanding, so what you're envisioning is the staff would extract the critical information, give it to the commission, and then if the commission requires further information from the applicant or the municipality, we would then send out, the commission would decide to send out a request for further information.
Well, we'd ask the staff.
Well,
Yeah.
Right.
True, and we would certainly do that, and that, I guess if the request was to develop a recommendation based on that, we would be prepared to do that as well. Granted, I think if there's additional information that is necessary, that we would have to go and get that information to the best of our ability to get it. Again, bearing in mind that our jurisdiction is over the licensee or the applicant itself.
So would that be like a public records request? Would it fall under the public records law, that type of request?
I guess it would depend on the information that's needed or necessary. But I guess we would use whatever ability we would have at our disposal. So again, if it was something we could get from an applicant, we would certainly seek it from them during, again, the inspectional process. But if it's something that we don't have ready access to, or the applicant itself does not have ready access to, we would have to find a means to do it or report back that we're unable to get that information.
How long would we anticipate the evaluation process taking? And think that's,
Once again, I'm sorry to keep doing this, we asked the executive director to tell us if the staff review during final inspection was feasible, how much time and resource it would take. I said in my introduction, what you're talking about absolutely would add time to it. We didn't ask the executive director to give us a recommendation, because I think, frankly, it's a commission process, which is, what are we gonna do, what kind of information we're gonna request, how long it will take. So Sean can certainly give an answer, but I just wanna make clear again that we didn't ask him to do an analysis of that. I think it's a very relevant question, but I just wanted to take Sean off the hook.
and that's understood. I realize that it hasn't been fully developed. Do you or does anyone else on the staff?
Anybody else in the staff? You're not asking the general audience.
Anyone else in the staff have an idea of how long it would take to collect the information that we would need to evaluate? Or, again, without background in municipal finance, what the information that we would be seeking would look like and what it would be, so what we'd be asking for. Does anyone have a sense of what that would be?
So if I may, I think it largely depends on the information being sought. So it would probably be a case-by-case basis, but if it was something that was not readily available, I think it's fair to assume that would take a degree of time. And it really depends, really specifically on the answers being sought, the information being sought, as well as the accessibility or the readily available nature of that information from, let's say, for instance, it's a municipality, or again, our jurisdiction being over the applicant or the prospective licensee. I'm relatively confident that if that were the request, if it was from a licensee, that we would ascertain it in a pretty short amount of time. But again, if it's something outside of our purview or control or jurisdiction, that would pose a challenge that, from a staff standpoint, we would try to overcome. But our ability to do that is hard to ascertain.
Okay, thank you.
Mr. Chairman?
Yes, Commissioner Doyle?
And this is, I'm sure you're grateful to know, not a question to you, just a comment to the commission. The other thing I think we would have to look at is also developing a standard for what information we are going to accept.
I would agree with that. So let me, if I could paraphrase, the request of the executive director to tell us about the feasibility and the time and resource requirement to do a staff review during the licensing process, I think, appreciate the responsiveness. This is a complex issue, and if we were to choose to do it, the issues that both Commissioner McBride and Commissioner Doyle raised, absolutely, and Commissioner Flanagan, they're all important issues. We would have to flesh that process out carefully, and I don't think we're in a position to do that now, and frankly, I'm not sure we're gonna need to. It depends on whether we decide to go that path or not, or at least decide to explore that path further. So I'd actually like, if it's possible, to, unless there are other questions about Sean's report, to get into what we think we should do here. But Commissioner Doyle, go ahead.
I want to thank you for taking the time to put together that analysis. I know that a lot of thought went into it from various members of our staff.
Very true.
Thank you. In our application and inspection process, to the extent that we review legal documents such as leases to determine a property interest or management contracts to determine ownership, who performs those reviews?
Day-to-day is conducted by our Director of Licensing.
Okay. And how is the training done for that?
The training for that was a number of us going through it and developing protocols, procedures, and really will boil down to a checklist.
Mhm. Do we have the right, under our law and regulations, to ask for contracts that the licensee has signed?
We have the ability to inspect documents during the course of our inspection process, yes.
It would be helpful to know the proportionality of the 1 hour. Do you have an estimate for the entire inspection process, how many hours that is?
It's largely gonna depend on the license type itself, the size of the facility, the activities being conducted, whether it be currently or prospectively. So again, if it's an existing R&D, it's an operation that's already functioning versus I guess a standalone adult use licensee that is really let's use a cultivation example, a built-out shell of a building that may have rooms but not actual product. So I guess hard to say definitively 4 hours, 5 hours, 6 hours. It's largely gonna depend on the individual inspection itself. I guess the developing the hour time frame was the time required to sit and physically with a, let's say it's a 5 to 10 page document, review the document itself to ensure that it is the host community agreement, and then extract that information and reduce it to an inspectional report. So, like I said, I don't wanna be flippant about it, but it was really how much time would it take to read, say, up to 10 pages or a bit more, and extract information, whether it be clauses or provisions.
I don't think that's flipping at all, that's still what you're doing. So to be clear, is the analysis that we would not need to hire any additional staff?
For the specific purposes of pulling this
For this
information?
specific purpose?
Specifically for this, no. It would just be during the course of our regular inspection process. And the volume of inspectors or investigators will ultimately depend on the volume of licensees.
Have any concerns been raised about whether attorneys or non-attorneys are reviewing the other legal documents as part of this process? And how have those been handled?
Not that I'm aware of, but not that I'm not aware that there's been any concerns raised during the course of that review.
Okay. Do you think that our investigative team is capable of looking at a contract, specifically a host community agreement, and determining whether a community impact fee is more than 3%?
I guess that's a harder question for me to answer, given the abilities and skills of investigators are going to vary, in some cases significantly, based on whether it be expertise or training, but also the provisions of individual contracts themselves. I would be uncomfortable saying that a non-attorney would be capable or prepared or trained to evaluate the contents of a contract and the meaning of those contents as well. So I'd be uncomfortable making that commitment.
Would it be the same answer in terms of whether a contract has a term of 5 years or longer than 5 years?
I think it would be, given the, I don't know, I'm not aware that the provision is that, and again, perhaps unartfully, that clean as being, it expires on this date. From what I understand, it's not always that clean. So I guess I would not ask our investigator to do that.
But you would be comfortable asking them to extract the relevant information?
Absolutely.
And that's what the specific timeline in the resource proposal is about, extracting that fact.
Mm-hmm.
That's right.
Thank you.
Sure.
Unless there are other comments about specifically the data that the executive director shared with us, I'd like to propose that we now re-engage in dialogue about what we should do and if so, how. And I personally believe the best way to do that is to kind of get as back all on the same page by reviewing, as I said, Commissioner Title, your proposal from last meeting. And I'd like to review my proposal from last meeting. Then I would like to, unless I will entertain a motion, obviously, if one comes up during that conversation, but my preference would be to let Commissioner Title review her proposal, let me review my proposal, engage in a dialogue and a conversation. I am more than open to other proposals as well, if anybody would like to make them, but I'd like to get that going, and then we can see where we are and you know, at the appropriate time, entertain motions. But I think that let's get the playing field leveled again before we start doing motions would be my preference. So if that's okay, Commissioner Title, are you comfortable going through your proposal again?
Sure. So I'm not making a motion because it sounds like there will be multiple proposals
there'll be
made,
plenty of
but
time.
I'll describe this.
Thank you.
So the proposal, not motion, is that the commission will require applicants to submit signed host community agreements and review them as part of its licensing process. The scope of review will be limited to ensuring that licensees are compliant with MGL Chapter 94G, Section 3D, including that the community impact fee is, 1, reasonably related to the costs imposed upon the municipality by the operation of the marijuana establishment or medical marijuana treatment center. 2, not more than 3% of the gross sales of the marijuana establishment or medical marijuana treatment center. And 3, limited to a term of 5 years, and that the host community agreement includes all stipulations of responsibilities between the host community and the marijuana establishment or medical marijuana treatment center. And I did not include a process, but were I to make this motion, it would include the proposal that the executive director just made.
Can I ask if anybody has questions of clarity rather than debating the merits of the proposal?
I'm a little worried, you might think my question crosses the line there, but I'll just.
I'll be a little generous.
Right, I'll ask it just, and then if you wanna postpone discussion of it. So, the thing that, trips me up when I look at this is, I think one of the things that has been, the controversy here is the things that are outside the community impact fee, those donations and that kind of thing. How would we address that in this process?
Well, I think the executive director's proposal makes sense, that that would be extracted into the information that was then presented to us as a commission.
Okay.
You haven't crossed the line yet.
Okay. So, but I'm not sure with this, so with that, if you're looking at the 3 categories that are identified and that you just read out loud, the way it's phrased, we're just looking at the community impact fee. And the concern is that the donations fall outside the community impact fee. And so I'm trying to understand how we're going to review those.
So it doesn't answer your question to suggest that that information would be extracted and then presented to us?
Well, no, cause the way it looks now, I mean, maybe, so it says ensuring that the licensees are compliant with 94G Section 3D. And I think some of the confusion in the conversation about this is a perception that all monetary transfers, I think that's the 2 divergent views. Should all monetary transfers between the applicant and the town fall under that 3%? Some of the applicants' representatives have said, yes, 3% should be the cap for all monetary transfers between the town. Municipalities have said, no, the statute identifies community impact fees as one thing that is authorized, but it is not the only thing, and so these other donations are allowed. But where I struggle with this is, how do you evaluate whether those donations are lawful? And that's where I'm struggling with this, is I don't know what standard we would apply.
Would it help if the definition of community impact fee was added to the motion and that could clarify?
So that would also sort of add a concern of, there isn't a definition, is there, in the statute?
If the language from 3D was added?
Yeah, I mean, I don't think community impact fee, you're saying the language in terms of costs imposed by the impact, okay. But some of these monetary donations, based on the review, and I know we're sort of wandering into the discussion.
We are, but this is important, so.
Yeah, so some of the donations have, and we talked about this, I think, 2 meetings ago, to do with public health education and things like that. And so the debate is that, that an impact of the facility within the town, or is it sort of a more global impact of legalizing adult use marijuana in the state, and therefore should be considered separate? And if it's considered separate, how do you evaluate it? And where the statute hasn't, put any constraints on the things outside a community impact fee, how can we review them in a way that would then be legally defensible if we found them to be inappropriate? So that's where I'm struggling, is trying to find a standard to apply.
We could expand the community impact fee section here and put comma, referring to costs imposed upon the company. Would that help?
Honest answer is I don't think so. I appreciate, we're trying.
Can I just, I think we are a little bit crossing the line.
Yeah.
So I think these are important issues, but I'd rather bring them back up when we have the debate. Is that all right, everybody? So that one option we have is Commissioner Title's proposal. Maybe we can modify it based upon this conversation, but that's a starting point. It's Commissioner Title's proposal. I'd like to just reintroduce a proposal that I made at our last meeting. Pride of authorship, be damned. But I listened to this conversation, and I have read and studied and talked to as many attorneys as I possibly can. I've read as many community host agreements as I possibly can over the last couple of weeks. And for whatever it's worth, and I'm not stating these as unarguable facts, but this is what I believe. One is I believe that there are some issues with the host community agreements that I've seen. That's my opinion. I'm not a lawyer, but I believe there are. 2 is the conversation that we just had, to me, illustrates my big concern, which is there is ambiguity. You can talk to as many lawyers as you want to, and you will find differences of opinion on what is in and what is not in the community impact fee, as per the conversation we were just having. You can also find lawyers arguing both sides of the debate of, do we have the right to intervene in these contracts, or to deny an application if we think the contract's out of balance? I know everybody has strong opinions on that, but I will tell you that there are equally strong opinions by respected attorneys on both sides of that. I will also say that there's also a difference of opinion between respected attorneys on both sides of, not only do we have the right, but do we have the obligation to review these and to deny an application, or at least not approve an application, if we find the community host agreement to be out of statutory regulatory requirements. I'm not a lawyer, but I'm listening to lawyers, and I'm hearing very, very different answers. And with all due, I'm going to say this incredibly carefully, with all due respect to the legislature, and I mean that sincerely, I think that when you have a large number of attorneys arguing vociferously on 2 sides of the same issue, there's an issue of clarity of language of legislation. At least in my untrained mind, that's the conclusion I come to. That being said, that is the basis for the proposal that I made last time, which is I don't think we should include review of the host community agreements, in the approval process, the final licensing process. I do think we should study them. I think we should ask for them voluntarily from all applicants. I think where we don't get them submitted by applicants, we should get them through public information requests, if they are public documents. I think we should study them when we have a large enough sample size to conclude as a group that we have an issue here, or maybe we don't, but form a conclusion. If the issue is that we have, if the conclusion is that we have an issue here, and I believe that's likely, but not certain, then I think we need to, as a group, as a commission, say, do we think that the answer to this is legislative text? Or do we think that it's a
think we would appreciate if you consider a fix here. I don't know how that's gonna play out. I do think that we need to study this. I do think we need to, as a group, conclude whether there is an issue here or not. And we also, if we think there is an issue, need to agree as a group, what's the right approach to resolve it, which might or might not be asking the legislature for a fix. I don't wanna commit to any course of action until we've done this review. But I think that's the right thing to do. I find I cannot support intervening in this right now, given the fact that there is such an incredible diverse opinion between respective attorneys on whether we can do it, whether we have to do it, what basis we should do it on, what's in or not in a community host agreement. I don't live my life trying not to get sued, but we will get sued, 100% certainty. But more importantly, I think we're gonna take, if we were to do this, we would be taking action on the basis of something that is legally disputed. And so my opinion, for whatever it's worth, is that we review them, study them, come to a decision whether we have a problem here or not, and if we do have a problem, figure out what the solution is, including potentially asking the legislature for a fix. So that's my proposal. I'm happy to answer any clarifying questions before we start debating the merits of my proposal. Sure.
Yeah.
Take
Go
a-
ahead,
take a-
Commissioner.
With all
Clarifying
due-
question.
With all due respect, Mr. Chairman.
You know,
First of all-
I think with all due respect should be eliminated from the English
You
language.
just used it, so.
Yeah, but not with the tone you just used it.
It's been almost a year, I've been very good. With all respect, Mr. Chairman, I think that everything that we bring up here today is important, and I know that you've said it over and over again. I think this is a messy issue. I think that, you know, we are regulators, we are trying to regulate an industry in Massachusetts, and regardless of what our counterparts in other states have done, I think we've been trying to really pay attention to the 351 cities and towns in the Commonwealth. So, you know, my point of clarification is that Commissioner Title had a proposal that I thought we were gonna talk about first, and then you have a proposal, and now it seems as though we're just gonna cross lines and get into this whole big mess. So my question to you is, what are we doing first?
I think
Are
we
we
should-
going to go one
I'm
way?
happy,
Yeah.
I'm happy to go through Commissioner Title's proposal, but I also want to leave room for if there are other suggestions about how we might approach it, but I'm certainly happy to go through Commissioner Title's. All I was doing, I was not trying to advocate, I mean, I obviously was, you know, making the case about how I came to my recommendation, but I wasn't trying to advocate nor start a debate as much as just level the playing field. But I'm perfectly happy, I think it's perfectly appropriate to talk about Commissioner Title's proposal as the first order of business.
And then we'll do yours later.
If necessary, maybe we'll all just say this, you know, that's the right idea, yeah, but I would start there. That's my proposal, Commissioner Title?
Yes, okay. When we got the materials for this
Sure.
meeting,
Yeah,
there was a link to a folder with several host
Yes.
community agreements that
Yeah.
had come in.
yes.
So we've all had a chance to look at
I
those.
can't say, we've all had a chance, I don't know if they're written down, but it's been available to people.
Right.
Yep.
Okay, do people feel like they need more time with those? Because if not, I guess my question is just, what would change? Because we already have them, that's my question.
Well, there's, how many of them in this folder?
More than
okay.
20?
I think I counted 17, but they're, you know, I agree with there are 17 or 20, whatever. So what's the
No,
implication?
it's a genuine question.
Yeah.
What more information do we need to evaluate before we would decide, for example, if there needs to be a legislative fix?
So I guess, I guess
That's starting to get into the debate, I think, of the merits of my proposal, but I'm happy to answer
No,
the
it's
question.
a real
Go-
question.
go-
Do you
go-
not
go-
feel like you have enough information?
Go ahead,
That's really
Commissioner
my
Flanagan,
question.
I'll answer the question.
Okay.
so I guess my first question, again, I'm gonna preface it by saying I'm not an attorney. I don't do contract law, I don't do any law. I used to create laws. And, when we talk about impact fees, and we're talking about what it's gonna cost the town, we're sort of forecasting what we think is gonna cost the town in the first year, right? I think the difficult part about this is that it's day one. I mean, we are on the ground floor of this building, and we are creating this industry. And so 6 months from now, while these agreements may try to incorporate everything that could be an impact to their town, what if that changes? Like, I guess I'm just concerned that we're talking 3% impact fees, and we don't necessarily know all of the impacts. Starting today, I mean, 5 years from now, this is gonna be irrelevant. This conversation is gonna be like, we can't believe we went through this. But I think my concern, when you look at small towns like, you know, Amherst or Shrewsbury or Athol, we don't necessarily know what the impacts are yet because they're not there. So when we start to talk about extracting information and how much someone's gonna have to pay a town and how much they're gonna give to a charity or what they're gonna do, how do we determine that now as to which way to go?
With compliments to you, not just due respect. The legislature.
Well, thank you, I don't get any
laid-
compliments, I get due respect.
The legislature laid out an exact answer to that process, which was you start out looking at your potential anticipated costs, right? You can charge a certain amount, you can't go over 3%, and then you document the costs, and then they're a public record, and after 5 years, you go back and look at it.
Well, now, and I'm just asking process, do those get adjusted after the first year? Like, what if it
They
changes?
could. I've seen different things in the different contracts.
That's just
So,
my.
yeah,
that's
no,
just
but I
my
think we're trying to get a little bit to the debate. So I'm gonna just assume that from now on, every time I open my mouth, the first words are with all due respect, so I don't have to keep repeating myself, but with all due respect. We have seen, I don't know numbers, but I thought I saw 12 to 15, but I read whatever was in the file, however many there were. And as I said, I think that there's some issues, at least in my non-legal perspective, I think there's some issues with specifically the impact fee, not even the issue about whether, you know, donations on top of that are in the fee or shouldn't be in the fee, but just in the fee itself. You know, fixed fees, as an example, as opposed to 3%. Prepayments, but particularly, you know, terms, where, you know, some of them just go on forever unless there's an explicit agreement not to, or there's a mandatory renegotiation and extension. So again, not being a lawyer, I think there are issues here. Two things. One is the practical reality is I'm gonna defer to the experts here that have been in the legislature. I don't think it's
I
anything.
didn't write this bill.
But I'm just saying from the legislative timeline.
So the reality of the legislative
Yeah,
timeline
thank
is
you.
that they are out of session until January, till the first Wednesday in January. They're going to be sworn in, at which point they are going to get committee assignments, which history tells itself is not till February, the end of February, which at time they're going to have to create their committee rules, and then the bills are going to be moved. You're talking March or April before these bills start to move.
So thank you, Commissioner. And so part of my reason for saying, you know, let's study it, we have the time, because I don't think we're gonna be able to effectuate. If we collectively study this and decide that we think that we need to ask the legislature for a fix, you know, it's not gonna happen until the timeline that Commissioner Flanagan just talked about, which means to me, why don't we study it? The other reason we're studying, aside from a relatively small sample size, whether it's 10, 15, 17, 20, of 351 cities and towns, and who knows how many licenses. The other reason for studying it is there is and I think you might have said this yourself, but if you did, I agree with you, there's a potential bias in the sample we have right now. Because the ones that we're looking at are the cities and towns that have gone ahead and said, yes, we want to allow these facilities in our town. Those that, and you know, this is hypothetical and speculative, but those that are using that might use host community agreements as a way to kind of make it difficult, we haven't seen those yet. And so I just think, since we don't have the option of getting legislative action more quickly than what Commissioner Flanagan just articulated, and I think we have a small sample and a potentially biased sample, I prefer to look at this some more. That's my logic. Sure. But we're not doing what Commissioner Flanagan said, we're just debating your thing first, but go ahead.
This might be clarifying question,
Okay.
or it might be
Sure.
substantive, you decide.
Okay.
What would
What
we
about,
do if
where's
we?
the, with all due respect?
I'm not gonna say it.
You get lost.
So for March and April, if we waited that long and studied, what do we do with licensees in the meantime?
And I'm not asking for the debate, my recommendation is that if we stick with what our currently we've been doing, we're saying we only require certification that a host community agreement has been signed by the city and town and the license applicant. And so continue essentially the process that is in place right now, which is what we're debating. But that's part of my recommendation. You can certainly disagree with it, but explicitly that is part of my recommendation. Any questions of clarity or clarification before we start talking about Commissioner Child's proposal? Okay. Then I'd like people, if they have questions or comments about Commissioner Child's proposal or tweaks that they would suggest on whatever, let's begin the dialogue on that.
Commissioner Doyle?
I can go back to the point that we were talking about earlier and we
Yeah.
decided was sort of drifting over the line. I guess the concern that I have remains that I've done a lot of research in the last 2 weeks trying to get ready for this and find a way, if there was a way, that we could review this in a way that I thought could stand up to a legal challenge. And then also sort of think about how the process would work. And obviously I didn't see this slide until a few days ago, but the concern I have with the potential review process is that we're gonna be holding people up. We're already, getting comments that it's going too slow. And I think where we're looking at that area of monetary transfers that are not easily fit in the community impact fee, which I agree with you is described as the impacts caused by the operation on the municipality, but instead these other donations, there isn't, that I could find, clear law saying what was okay and what wasn't okay in community benefit agreements. And I actually looked all over the country to try and find it. So my concern is, without asking for help from the legislature, based on the new information we've acquired through the development of this process, that we're going to potentially delay people. Our only authority right now is to deny applicants, which I'm,
Or at least to refuse to approve. Well,
Yeah.
but go ahead, I'm sorry for that, I apologize.
No, that's okay, no, it's part of the discussion. Where we don't have sort of clear standards to apply, and if we try to develop them ourselves, may be subject to a challenge because they don't appear in the statute, and, we could get accused of exceeding our statutory authority. So I realize I'm sort of talking about the two different proposals at the same time, but for those reasons, I actually would be more comfortable with the idea of asking the legislature for help based on what we've seen, and just asking for clarity as to what their intentions were. We have two legislators have told us what they thought they were, putting in place, but the plain language of the statute is a little bit different. And it would, I think, benefit us to get a reconciliation of the two different points of view. The legislators who said they thought it was supposed to be this, the plain language of the statute, see if we can reconcile that so we have a clear legal footing to go forward. In the meantime, licenses can go forward, but when and if that statute is amended, perhaps there be some sort of, reform period where they are given a certain amount of time to reform contracts in line with whatever the legislature tells us they want it to be.
You want to respond to other comments?
No more comments.
Any other comments? Commissioner?
You can tell me, I guess, if I'm
Pardon?
listening, you can tell me.
No, we're in the debate, so we're no longer into clarifying questions, so you can say whatever you want.
So, I don't think that I need to, I don't think there's any surprise. I've gone on record before about what my concerns are. I have concerns about our authority, I have concerns about delays, and I'm concerned about what people's expectations would be of the outcome, if we were to undertake a review of post-community agreements. And for those who characterize these concerns as disingenuous, they haven't been listening for the past year. As I've said before, we're a regulatory agency. It's our job to establish a balanced regulatory process, and that's different than a government-run process. And my concerns about our ability to undertake a review are anything but disingenuous. They're based on law and they're based on experience. And I can reiterate that we have no authority to require a municipality to do anything. Given the limits of our authority, the only action that we can take, I would propose, is against the applicant. who presumably will need to approach a municipality to renegotiate a contract that may or may not happen. Now, as an aside, it would seem that the people who would really be benefiting from that process, if it were to be put into place, would be the people who advised the applicant in the first instance. The applicant signed the contract. You can insert the adjective to describe said contract there.
We'll leave that out, okay.
And then would be able to go back and ask the municipality to renegotiate that contract, all the while charging the applicant for doing that. And so, it's my editorial comment that it has been said before that this law is a full employment opportunity for Commonwealth attorneys, and I think that we would be proving that point if we were to move forward with that. I have concerns that reviewing these will result in delays in licensing decisions. And these circumstances will be different than other circumstances because they will be of our own making. Examples come to my mind of other.
I'm sorry.
So,
Last sentence, I
these
apologize.
circumstances, if we decide to move forward with reviewing host community agreements at this point in time, with no ability to affect the outcome of if we determine that it's not compliant, then we are going to be choosing a delay here. It's not like the other circumstances that people have pointed to as reasons for maybe there being a slower rollout than some would like. Things like banks. We can't force a bank to come to the table and bank a marijuana establishment, but we can establish a regulatory structure that hopefully will provide banks with faith and make them want to come and take a risk on this industry.
That's when we heard that.
Yeah, we can't force someone to apply for an independent testing lab license, but we can put a proposal into place to allow people to apply by August 1st and then say that we will take those licenses and review them. Here, we can't force a municipality to renegotiate a contract with an applicant. If we decide to go down this path, I have concerns that we are going to be making a choice with eyes wide open to delay the process for everybody. And you can go ahead and you can Google Massachusetts agency and backlog, and I came up with over 400,000 hits when I Googled it.
About our agency?
No, about agencies
agencies.
throughout the
Oh, I'm sorry.
Commonwealth over a course of many years. And we're talking about administrative agencies. And in case anyone has any doubt about how a delay that we choose would be perceived, all you need to do is Google search it. Some of the stories are written by the people in this room. Many of the people in this room have covered those stories, and you will see it there. The story writes itself. So now, if it's really true that I didn't care about delaying this process, I would vote to review that, and that would be disingenuous. I'm not going to do that, because I believe that in making that choice, we are taking on a delay with no certainty of a beneficial outcome, even if we identify a problem. And so I would implore us to move forward, establish the responsible industry that we said we were going to establish, get some provisional licenses out there for independent testing labs so that we can start to put our supply chain into place and do this. Let's do this thing. I mean, I think that if we are making other choices, then we are going to be owning those choices for years to come, and that we are going to be reviewing a lot of complaints, and that we are going to be possibly open to legal challenges, and that makes me concerned. So it's not an easy, as we've identified already, it's not an easy question, but I think it's one where we have a choice.
Thank you. Other comments?
I have some remarks as well, but first, I just wanna apologize if, when I said I felt that certain remarks were disingenuous, if you felt like that was directed at you. I'm sorry.
Can I ask you, past tense? Thank you for
Okay.
saying that, but let's keep that.
I mean, I'm sorry.
I appreciate that.
Okay. I'm thinking back to the background check discussion, which I thought actually, we came to a good compromise. And against, automatic exclusion for people with heroin trafficking convictions, and I realize that that's something that people are not gonna agree with. But, there's a lot of bureaucratic delays that go with background checks too. I think that, you know, it adds weeks to do certain background checks. It's very expensive, it's $400 a person. And I didn't focus on that because I think if it's the right thing to do, it's the right thing to do. And I don't believe that, people with drug convictions should be automatically excluded, and I was upfront about that. So, I believe this decision of reviewing host community agreements is possibly the most important, the most significant decision that we're going to make in terms of how we affect what happens with this industry. I want the record to be clear, no matter what happens today, I can't control the decision, but I want the record to be clear that I tried my hardest to change the path that I think that we are headed on by making this motion. I had made it at the last meeting. We came back with more information about the costs. We came back with more information about the specific agreements. I think, unless anyone feels otherwise, that we have all the information that we need to make. In terms of a legislative fix, I'm not a politician, I'm not extremely familiar with the process, but I know there was a suggested legislative fix in the fall that seemed to everyone I talked to be pretty uncontroversial, and that didn't pass. So I would have concerns about thinking that a legislative fix would address this problem. I know how significant this vote is because I have worked with many marijuana businesses in Massachusetts over the years, and even though I'm the only one in this conversation with that experience, there are, I think it's unanimous if you ask people who are in the business of any size, what is the hardest thing to get through in Massachusetts, they would say the local process. And I think that's a big factor in why in 2012, we were supposed to have 35 dispensaries open immediately under the medical program and then many more afterwards, and we still only have about 35, I think 38. And I think we are setting ourselves up for exactly the same process now. And it's not just a barrier to entry like the other ones that we've tried to reduce, the fees and the simplicity of the application process. We've worked so hard to reduce those barriers of entry. We've made an equity program, we've worked with farmers, we've worked with solo entrepreneurs. All of that could easily become moot because the local approval process is the mother of all barriers to entry. And if you talk to anyone in the business, they will tell you about it. And it sounds differently if you ask a large company, they might say, it cost me a lot of extra money, I didn't feel like I had negotiating power, it's not fair. If you talk to a small business, they might say, you know, I tried once, I couldn't even get a meeting. Or, you know, I tried to negotiate the 5-year term and I didn't even come back to a meeting because it's that difficult. And we all get those comments every single day. So back in December, we voted 3-2 that we would not review those agreements. And I think it was fairly understandable at that point to expect that businesses and municipalities would at least follow the quantifiable parts of the law, the 3%, the 5%, the 3%, the 5 years, and documenting costs. But we let it play out for several months, and now we're revisiting this decision with evidence, and we can't pretend like we haven't seen those agreements. We've seen them. When I looked at the agreements, I want to stress that none of the agreements for the provisional licensees struck me subjectively as particularly egregious. And I think what the chairman was alluding to earlier when I said that I thought our sample might be biased, I was saying that those municipalities that have signed community host agreements, they're the ones that did this first. They said we're willing to have marijuana businesses in our town or city, and by no means am I calling them greedy. I love those municipalities. I think that they're going to be the models. So I'm not criticizing them. I'm not criticizing the licensees. What I'm criticizing is the system that we are setting up, because if we don't set parameters now, if we issue final licenses to businesses that have clearly, in my opinion, non-compliant contracts. So for example, requiring a business to pay a municipality 3% of their gross revenue and sales, but also $10,000 here, $25,000 here, I've seen that in the contract, then what will our basis be when we see one that is truly egregious? Because they can say to us, and they would make a very fair point, what authority do you have to draw a line now when you haven't drawn a line in the past when these agreements have exceeded the law? So back in the campaign, people talked a lot about big marijuana, capital B, capital M, big marijuana. I haven't seen any concerns about that yet, but it's kind of a general public health concern in the back of my mind that I think about. And if we continue in the path that we're in now, what is to stop a big marijuana company from coming in and offering to pay a community host agreement, community impact fee of 3%, and then $1 million flat fee? And we wouldn't have any way to stop that. And worse, despite a strict limit in the law of 5 years, we are seeing agreements that say 5 years and then we'll try to renegotiate, but if we can't come to an agreement, the payments will just continue as they are in this agreement and can never be reduced. That's not a 5-year term, that's an indefinite term. So if we ignore it, are we saying we'll just turn and look the other way? Are we going to keep issuing licenses to those businesses? And the idea that it might get worse is not hypothetical, because when we asked for people to send us agreements, not only did they send us the agreements for the provisional licensees, they send us agreements for businesses that have been signed but haven't come before the commission yet. And I saw things like 3% plus a 1% voluntary donation. That's voluntary, but you have to commit to that before we'll even have a meeting with you about an HCA, and that does not sound voluntary to me. Now, I said earlier that I think we're actually on the path to creating a worse situation. That's what's under the medical situation. And the reason for that has to do with the provision that I saw when I was reviewing the agreements, and almost all of them, if not all of them, had this, and it's called a reopener. And what that says is, if you and I have a contract, and you're the business and I'm the municipality, and we come up with a payment structure, if you go and open another business with another municipality and you pay them more, then the same terms apply to me too. So almost all of these agreements had it. So if you're a business and you are in 4 municipalities, whatever is the most payments that you agree to pay would now apply to all 4 contracts. And then think about it, if you're the municipality, now you're gonna say, well, I have to be fair, so now I have to ask every business that wants to locate in this town or city to pay that amount too. And it causes this chain reaction that I can see playing out in front of my eyes as I read these agreements that will knock out the smaller players. And that is why I care about this. I don't care about this because I'm trying to be mean or I hate municipalities. I care about this because I was asked to do this job to look at this industry and try and make it inclusive. And if you say, well, this is just how it works in every industry, you have to go to a municipality, you have to pay lobbyists, you have to pay fees. First of all, I don't think that's true, but second, even if that is true, I wasn't asked to make those industries inclusive. And I haven't seen a law that says there's a limit on the number of payments that you can make. There is for this industry, and I think we need to enforce it. So, on the topic of whether these agreements are fair or not, that's not for me to say. They seem kind of fair, maybe, but we have requirements like if you are if you have this, like your security cameras have to keep recordings for 90 days, right? And so if they keep recordings for 80 days, we wouldn't say that seems close enough and you seem like a nice person, so we'll look the other way, right? So 3% plus $10,000, maybe that doesn't seem like much, but the question isn't, is it fair? The question is it compliant or is it not compliant? we have so many obstacles in front of us when it comes to including farmers, micro businesses, people of color, women, veterans, disproportionately impacted communities. And I've sat up here and I've approved 19 licenses, and I haven't seen any evidence of those groups in front of me. And there's this gigantic barrier to entry that we could choose, if we just enforce the law, to remove. And we would still face all those other obstacles, but we're willingly going to look the other way. I think this is going to be a historic decision. I'm thinking about the big picture. I'm thinking about what our industry will look like years from now. And you don't always know when you're in a history-making moment, but I get enough phone calls from people in other states saying, what do you think they did wrong in Colorado? What are you trying to do right? And I know they're going to get the same calls, and they're going to say, what do you think Massachusetts did wrong? Or I hope, what do you think Massachusetts did differently that they managed to make this an inclusive industry? And I don't know which way it will go, but it all comes back to today, and I don't want any regrets that I didn't try my absolute best.
Thank you. Thank you. No, please, thank you. Go ahead, Commissioner.
First, I want to thank Commissioner Title for the work that you've done and that you do. I think it's very easy to look up here and see 5 different people that have been appointed for 5 different reasons and try to stand up an agency and build an industry in Massachusetts that has never been done here before. And I think that we're coming up on our 1-year appointments, and there's a lot of historic decisions that we're making in Massachusetts. We've made a lot of decisions in the last 12 months that have affected many people across the Commonwealth. There have been unintended consequences to some of our decisions. There will be unintended consequences to our decisions. And we're trying to do what we think is best for Massachusetts. And from my background and my 22 years on Beacon Hill, I know what happens when you make a wrong decision. I know what happens when the decisions you make affect a family, affect the life, affect the community, affect a municipality. And I know the fact that the United States is constantly watching Massachusetts because we've seen it time and again with education and healthcare and transportation and public safety and now marijuana. I've gotten the calls from across the country, just as I'm sure many of my other commissioners have gotten the calls across the country. 1, to offer assistance, 2, to suggest things that Massachusetts could do right, and 3, asking what the future holds here. There have been a lot of decisions that I've had to think about before I casted my vote to ensure that 351 cities and towns have been thought of. And I will tell you that, in my legislative career, inside 128 has never really mattered to me. It's always been outside 495. Because those are often the forgotten towns.
What about between 495 and 128?
You have to think about that for yourself, Mr. Chairman. And so, and it's been, you've heard me say it, there are 351 cities and towns. Question 4 did not include the farmers. We need to think about farmers. People out west want to farm. They're gonna get 1 grow season. God love them with their farms, they're gonna get 1 grow season and they still wanna get into this. We have craft cooperatives, we have transporters, we have micro businesses, we have all these small businesses that we have established under our regulations because we understand that there are obstacles and barriers to this industry. The reality is you need money to be part of this industry. And while not everyone is going to own the businesses that we're going to license in Massachusetts, people have an opportunity to work in the businesses that we are going to license in Massachusetts. And while that doesn't make everybody happy, the one thing that I can say with the most certainty is that we cannot be everything to everyone all the time. We are a regulatory agency. If there are ways that the legislation needs to be changed, that has to be done up the street. That can't be done here. We have to work within the parameters of the black and white that is on the paper that we now are sure with regulating. And we've been entrusted with this by the people that have put us here. I have concerns that if we start going into these community host agreements, and again, I'm not an attorney, that we are going to be sued, that we are going to delay the process, that a simple hour of, an anticipated hour of inspection, if we don't get it right, then we're gonna come back and we're gonna be told that we did it wrong and we didn't have the right people doing it. I trust our staff implicitly. I think they've done a great job From the time they got here until today, it's sort of been, building the fire truck as we're on the way to the fire. But I think we have to think about what we want this industry to look like in Massachusetts. I understand that there are barriers to this. I understand that the municipalities, there can be obstacles. That has been said in many different industries in Massachusetts. It's been said many different times. But Massachusetts is set up with 351 independently operating cities and towns. That's not going to change under our purview. We can set a guidance, which Commissioner McBride has given to us with community host agreements. It's from my understanding in reading some of these community host agreements that there's a condition in there that if anything becomes illegal or invalid, that they've got to go back and do what they have to do with this. To me, that's a way that if we say as a guidance, this is what cities and towns have to do with regards to applicants, then this is what has to happen. We can be difficult, we can certainly be difficult. But my concern with us now becoming the entity that oversees reviewing these applications is only gonna delay us further. And like I said before, the campaign is over. It is done. We are here regulating the industry. We have provisional licenses that we've given. We've got more that we're supposed to do today. We have applicants that are trying to be part of this, but at the same time, we have got to be realistic in managing the expectations of this commission and the actions that we can take. It hasn't been easy, it's not going to be easy, and believe me, I don't want big business coming in here. I want the little guy to be able to succeed, but at the same time, it can't all be handed to the person. There has to be parties negotiating. We have to be able to trust that process, whether we agree with it or not, because it's here. And so, Mr. Chairman, if the legislature wants to give us clarity, I appreciate that. I understand that we've gotten a letter from the chairs of the committee. I was there during the debate on the Senate side when this was done. I voted for the law, and I think that we need to try to do what we can to move forward and to get people licensed and get the doors open.
I'm happy to go last. Are there additional comments from Commissioner McBride? I'm not trying to put anybody on the spot.
Yeah, no, I think I've pretty much said my piece. My concern lies with those fees or donations, or whatever we want to call them, that are outside the purview of the community impact fee, and I support your suggestion to study this. I would also add that I'd really like to do, as part of our research agenda, into Commissioner Title's point, the issue of what is actually slowing people down. And I think we started that with the economic empowerment applicant survey. I think we need to follow up on that work and keep drilling down and really do sort of the kind of reporting that Colorado has led the way on, and really examining our market and examining what's happening.
Commissioner Bryan, anything additional you'd like to add? Thank you. Go ahead.
Just a quick point on the whole being sued thing. I agree with you. I don't tend to make decisions that way, but if I did, I think I would consider that the two lawmakers who led the drafting of this language, Senator Jalen and Representative Cusack, wrote us a letter saying that the intention was for the commission to enforce this, and also that we issued our own guidance, which was fantastic, and I think that the court would look at both of those things, and the law, most importantly.
Thank you. Yeah, this is hard. I don't know whether it's historic. I think everything we're doing is historic, but I agree this is a hard and incredibly important decision. Point one. Point two, I thought you were extraordinarily eloquent. And point three, this is not fortuitous. I agree with pretty much everything you said about the issues and what might happen in this. My sticking point, and I don't know how to get past it, my sticking point is not, again, respectfully to Senator Jalen and Representative Cusack, my sticking point is I'm hearing 10 attorneys on both sides adamantly arguing the opposite point here, and our general counsel. I hate to put her on the spot, but we have a general counsel to give us legal advice, and our general counsel's legal advice is that we do not have the authority to intervene here. I have both the benefit and the consequence of being, not being a lawyer. So I don't have an informed legal opinion on this, but I have enough, and like everybody else here, I've been agonizing on this, and I've been working this issue very hard because it's an incredibly important issue. I don't feel there is legal clarity about our ability to intervene. I just don't. And you can say I should, and maybe I should, but I do not have clarity in my own mind based upon the legal advice that I have been, or the legal opinions that I've been hearing. I do not feel I have clarity about our legal ability to intervene here. I believe, as a citizen, not just as the commissioner, chairman of the commission, as a citizen, when you get lawyers arguing vociferously on both sides of the law, it means the law is not as clear as it could be or needs to be. And so my opinion is we need to get help clarifying the law. That's my opinion, it is not a fact. And I do not feel comfortable with that lack of alignment among the legal opinions that I've solicited, that we have the authority to go forward here. I don't want to get sued, but my objective here is not to do something to avoid getting sued. My objective here is to do the right thing. Just like my objective here is I don't care about what is written in the paper, I want to do the right thing. So this is not about avoiding lawsuits, this is about doing the right thing. It is very clear in my mind that this is ambiguous and undetermined about whether we have the legal authority, and I know you differ in your opinion on that, but I'm hearing equal and equally adamant arguments to the other side. So I really think it's important. I just want to be clear. I agree with every single one of the objectives you articulated. I just don't believe we have the power to do what you're suggesting. And I would like to get that power, but I believe the answer is to get that power, we need to ask the legislature to provide us with clarity. That's my opinion.
Go ahead.
I don't think I'm going to persuade anybody of anything, but like I said, I do think this is a historic vote, and I'm pretty concerned about the record, and so because it's my motion on the table,
Sure.
I just want to make sure that it's clear that my motion does not suggest intervening in any way with any contract.
That's poor language on my part.
Okay. Thank you.
What I don't feel comfortable with is our ability to deny a license because it is our interpretation that these contracts are not compliant with the law. I don't believe it's clear that we have that authority. So, but you're right, thank you for that clarification, because I agree with you. I know your proposal is not that we agree in a private contract between, thank you. I agree with that.
Do you have something to say, Commissioner Rowe?
No, I was actually, to Commissioner Title's point about clarity of the record, can we circle back to what the motion is, just
Yeah.
so that, because I don't think it ever got seconded.
No, so
So-
we don't have,
I didn't
we do
Oh,
not have a
okay.
motion on the table at this point. I'm more than happy to welcome a motion if somebody would care to make a motion.
Sorry, and I just said it was on the table and it wasn't, so.
No, it's not
pointing
on
it
the
out.
table.
Okay, let's see. Okay, the very last thing that I want to address is just the delay.
Sure.
I don't see any evidence that there would be a delay on our end. Looks like it would be an hour of inspection and then it would come back to the commission for discussion. That's my proposal. If there was a delay in getting a new contract, that's a fair question. I'm gonna say in my opinion, you don't have to agree with me, I believe that the municipalities and the businesses that we're looking at, especially considering that they were willing to go first, I think that they are not going to hold out over an extra, say, $10,000. I think that we would see a new compliant contract pretty fast, but that's just my opinion. Okay, so I move that sorry, anybody have any other comments?
I think we're ready to entertain a motion.
Okay, I move that the commission will require applicants to submit signed host community agreements and will review them as part of its licensing process, including the process laid out by the executive director. The scope of review will be limited to ensuring that licenses are compliant with MGL Chapter 94G Section 3D, including that the community impact fee is reasonably related to the costs imposed upon the municipality by the operation of the marijuana establishment or medical marijuana treatment center, not more than 3% of the gross sales of the marijuana establishment or medical marijuana treatment center, and 3, limited to a term of 5 years, and that the host community agreement includes all stipulations of responsibilities between the host community and the marijuana establishment or medical marijuana treatment center. I don't know if I will get a second, but I will ask for one.
Thank you. So let the record show the commission that the motion was made by Commissioner Tittle, seconded by Commissioner Flanagan. I think we've debated this sufficiently that we can vote on it immediately without further discussion. So can I ask for all in favor?
Aye.
Commissioner Town?
Thank you. All opposed?
Nay.
Let the record show the motion was denied by a vote of 4-1, with Commissioner Tittle being the vote in favor and the other 4 commissioners voting against. Thank you. Do we have any other motions to entertain on this topic?
Are you gonna move?
I don't, I guess, my question for the general counsel is, does my proposal, which is really to study this and potentially go to the legislature if we think we need their help, is that a motion that should be made, or is that just something?
If you wanted to-
operating?
I'm comfortable with you just directing staff to do it, yeah.
I don't think you need to vote.
Pardon? So then I don't think I need to put a motion, but I will entertain other motions.
Wasn't your proposal to collect those community agreements?
Yeah, but I think that's what I was just asking about. I think I was told that we could just direct staff to do so
Right.
without a motion.
Yeah.
So that would be
That's
a
correct.
change in our application, just to be
No,
clear?
no, I'm not saying as part of the application process. I'm saying explicitly that we will make a request. Let me be very clear about this, okay? We would make a request of all applicants to share the community host agreements, but not a requirement. I am not suggesting that we review them as part of the licensing process. And where we do not get voluntary compliance with our request, we use public records requests to get copies of those. And that would be my direction to the staff.
Mr. Chairman?
Yes, Commissioner Doyle, if you want to help me out here, I'd be delighted.
May I just add, since it hasn't been mentioned yet at the meeting, that we are actually in process of a municipal survey.
Yes.
And part of which is collecting host community agreements from municipalities, as well as a lot of other vital information. And PSA to municipalities and others who would like to reach out to municipalities, the deadline to submit the responses is tomorrow, and the deadline is at 5 o'clock. So please, please, please get the information into us. It will really help us move forward and assist the municipalities in working to implement the adult use marijuana laws. Thank you.
Thank you for that commercial. My understanding, however, is that response is voluntary, correct?
It's voluntary, but
My point, my point is that it is a voluntary submission, whether it's through our request during the application process, whether it's through the municipal survey that you just referred to. And my hope and expectation is that the vast majority will get that way, but the ones that we don't, we have other means of getting it. So my direction to the staff is, I would like us to compile as complete a list of, a completed collection of these host community agreements as possible through voluntary submission and public record requests where we're not getting it. And we need to have the staff look into kind of a systematic review of what's in them, and at the subsequent commission meeting, discuss what, if any, actions we think are required, including, as I said, the potential of going to the legislature and asking for additional changes. But that decision will be made at a subsequent commission meeting once we have sufficient host community agreements collected by the staff and analyzed by the staff. Is that fair as a directive?
So, what's the end goal? I
The
guess
end goal is to see where we have, I'm sorry, go ahead.
we're gonna collect these, we're gonna see them, we're gonna do what's,
Well, I think the end goal for me, at least, I can't speak for others, the end goal for me is to have staff collect them, assess as a commission if we think we have an issue here. If we don't, then there's no action. If we do think we have an issue, based upon the collection and analysis, we decide as a commission what actions we need to take to respond to that issue, one of which might be asking the legislature for a fix. I'm not gonna presuppose what the other options might be, nor am I gonna presuppose that there's gonna be a problem. I think we see if there's a problem, and if there is a problem by our mutual agreement, we decide on what action. That's the end goal. And the action might include, but not necessarily, and maybe not limited to, asking the legislature for help in fixing the issue.
my one concern is that it seems to be that we're gonna have the same conversation we're having now. I mean, we have someone who says there are problems, we see problems, let's do, and then we're waiting until we get, I don't know, 50 more.
No,
I just wanna set the expectation of what we're going to actually do.
maybe I will be outvoted and maybe I will change my mind, but at this point in time, my belief is that we are going to need to, or at least I believe we should go to the legislature and ask for clarity and a fix in the language and clarity in the language. And the collection and analysis of these host community agreements to me will strengthen our case to take to the legislature. So that's what I expect to happen. I agree, we can certainly have another debate about whether we have the legal authority, but it seems like we've just agreed that we don't. So I don't imagine we're gonna reopen that, although, everybody on the commission is obviously willing to raise any issue they want to. But my expectation is we're going to decide if there's a problem that warrants us going back to the legislature and asking for help. And we'll have the data to support that, the data and analysis to support that. Does that address your concern?
This conversation may trigger that, they do it preemptively.
That'd be great. That would be a perfect example of what I talked about at the last meeting, which is the Hawthorne effect. But you shine a light on things and see what happens. But anyway, are there other comments or? Okay, I will only speak for myself, which is I am exhausted, so I need a break. So can we take a 10-minute recess before we get into the next agenda item, which is the recommendation of staff on provisional licenses? Thank you. So, those of you that can't tell time, 3 o'clock, we're gonna read.
In Salem, the license being sought is that of an independent testing laboratory. This applicant, because it is an independent testing laboratory, this applicant is not associated with any other applicant or provisional licensee. It is indeed independent. The folks identified or disclosed as part of the application, Brian Strasnick as owner, Eamon Travers as manager, and Brianna Cassidy as manager. There are no other entities other than the applicant that have direct or indirect authority over the establishment. This applicant has been deemed a priority applicant pursuant to the Commission's vote on June 26th to prioritize independent testing labs that apply prior to August 1st of this year. This applicant is a registered testing laboratory with the Department of Public Health. They do propose to conduct their testing of both medical and adult use marijuana in the Salem location. They have secured a host community agreement, which was executed on July 3rd, and certification's been provided. The community outreach meeting was held on June 29th, and notice was published in the Salem News. We did receive certification from Salem that there are no objections or no issues pertaining to compliance with local ordinances and bylaws. As far as their plan to positively impact areas of disproportionate impact, they plan to continue their history of philanthropic activities in the city of Lynn by donating to Project Cope and Girls Inc. That was not me.
I know that. I'm looking for the guilty party. You better keep going. I'm sorry.
Or was it?
Can you name the charities again, please?
Sure, it's Project Cope and Girls Inc. And the applicant will continue to aid the Lynn Community Health Facility, which supports local sober living projects. As far as the background check, there are no concerns currently on the application that were raised for individuals associated with the application, and no concerns on entities associated with the application. Similarly, there were no disclosures of any past civil or criminal actions, and no disclosures of any occupational license issues. There are also no disclosures of any business interests in other jurisdictions. The entity secured a certificate of good standing from the Secretary of the Commonwealth as well as the Department of Revenue. As far as the management and operations profile, they currently test marijuana and marijuana products for registered marijuana dispensaries in accordance with DPH's protocols, and they are capable of handling additional volumes of testing samples for the adult use market once a final license is issued. The proposed hours of operations are Monday through Friday from 8 a.m. to 5 p.m. and they were compliant with submitting the variety of summaries that are required. Those summaries have been reviewed and have been determined to be substantially compliant with our regulations. We will review these summaries during our inspection process, which will be required before a final license is issued. As far as a diversity plan, the applicant is committed to recruiting and hiring a diverse group of employees while promoting equity among all individuals. To achieve this, the applicant will participate in job fairs, engage with community groups for recruitment, and encourage diverse networks. The applicant will conduct continuous and regular evaluations to ensure its goals are in fact being achieved. Again, this is an independent testing lab, so there is no cultivation plan, there's no summary of products to be produced or sold, and no plan to obtain marijuana or marijuana products. They have secured their ISO 17025 certification from Perry Johnson Laboratory Accreditation. Therefore, the Commission staff recommends issuing a provisional license with the following conditions: that the final license is subject to the applicant obtaining certification as an ISO IEC 17025-2017 accredited laboratory. Final license is subject to the certification that the applicant remains in compliance with DPH's regulations. The final license is subject to an inspection and audit to ascertain compliance with our regulations. Final license is subject to inspection and audit to ascertain that their facilities are compliant with all applicable state and local codes, bylaws, ordinances, and regulations. That the applicant will cooperate with and provide information to Commission staff. upon request, and its provisional license is subject to the payment of an appropriate license fee pursuant to our regulations. We've based this recommendation on the applicant's demonstrated compliance with the laws and regulations of the Commonwealth, its suitability for licensure, and upon the evaluation of the thoroughness of the applicant's responses to the required criteria. We certify that we've done a due diligence review of the applicant, and as of this date, the applicant has demonstrated their compliance with the laws and regulations of the Commonwealth and its suitability for licensure, and we therefore recommend a provisional license with the mentioned conditions.
Thank you. Are there any questions or comments? Commissioner Doyle?
Yeah, sorry, just a clarification on their hours of operation, is it 5 or 5:30?
5:30.
Thank you.
Other questions? Then can I have a motion to approve the staff recommendation?
Second.
Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner Flanagan. All in favor? Let the record show the Commission unanimously approved the staff recommendation for the license application ILN 281275. Thank you very much. Next, please.
Mr. Chairman, thank you. The next applicant is MCR Labs LLC. The proposed location is 85 Speen Street, Speen in Framingham. The license being sought is that of an independent testing laboratory. Because it's an independent testing laboratory, the applicant is not a licensee or an applicant for any other marijuana establishment license. The individuals identified in the application are Michael Kahn as owner and partner, Scott Churchill, and Rostislav Gutman as director. There is an entity that serves as a holding company, which is identified as Cardboard Box Holdings, which is wholly owned and controlled by Mr. Kahn. The applicant is a priority applicant pursuant to the Commission's vote on June 22nd as an independent testing lab that applied prior to August 1st of 2018. This lab is registered as an independent, or as a testing laboratory with the Department of Public Health. They do propose conducting both medical and adult use operations at their Framingham location. They secured their host community agreement on July 31st of 2018, and certification has been provided. Their community outreach meeting was held on July 10th, and notice was published at least 7 days prior in the Daily News. We received certification from the municipality on August 13th, stating that the applicant is in fact in compliance with all local ordinances and bylaws. Their plan to positively impact areas of disproportionate impact includes the following: providing financial support to areas of disproportionate impact through enhanced and targeted donations and sponsorships to advocacy groups, economic empowerment, nonprofits, and local charities, providing discounted testing structures for economic empowerment applicants and other entrepreneurs from areas of disproportionate impact, and participating or hosting educational seminars and technical trainings with such groups as Mass Equitable Opportunities Now. There were no concerns raised during the background check as far as individuals associated with the applications or entities associated with the application, and no disclosures of any past civil or criminal actions, and no disclosures of any occupational license issues in other jurisdictions. The applicant did disclose a business interest in another jurisdiction, which is that of PCR Labs in the state of Pennsylvania. There is no issues that have arose from this disclosure. The applicant secured a certificate of good standing from the Secretary of the Commonwealth as well as the Department of Revenue. As far as their operations review, the applicant does, their timeline to become operational, they do currently test marijuana and marijuana products for RMDs in accordance with DPH's protocols, and they've stated they're prepared and ready to start testing for the adult use market once they receive a final license. Their proposed hours of operation are Monday through Friday, 10:30 a.m. to 5 p.m. They've submitted the variety of summaries necessary. We've reviewed those summaries, determined that they are substantially compliant with our regulations. Full compliance will be reviewed during our inspection and will be required before a final license is issued. As far as their diversity plan, the applicant plans the following: creating and sustaining a robust policy for inclusivity and diversity by recruiting individuals from underrepresented and minority communities, purchasing goods and services from vendors, contractors, professional service providers that are owned and operated by individuals that derive from culturally and ethnically diverse backgrounds, and measuring their progress of their diversity goals by establishing a diversity committee and requiring periodic management reviews to be conducted by its Director of Business Operations. This is an independent testing lab, so there's no cultivation plan, no products to be produced or sold, and no plan to obtain marijuana products. They have secured their ISO certification from a certifying body, That body is ANSI, ASQ National Accreditation Board. The commission staff recommends issuing a provisional license with the following conditions. That a final license is subject to certification that the applicant remains in compliance with DPH regulations, that the final license is subject to inspection and audit to ascertain compliance with our regulations, the final license is subject to inspection and audit to ascertain that their facilities are compliant with all applicable state and local codes, bylaws, ordinances, and regulations, that the applicant shall cooperate with and provide information to the commission staff upon request, and that the provisional license is subject to the payment of the appropriate license fee pursuant to our regulations. This recommendation is based on the applicant's demonstrated compliance with the laws and regulations of the Commonwealth, its suitability for licensure, and upon the evaluation of the thoroughness of the applicant's response to the required criteria. Commission staff certifies that a due diligence review of the application has been performed, and as of this date, the applicant has demonstrated their compliance with the laws and regulations of the Commonwealth and its suitability for licensure. We accordingly, therefore, recommend the applicant be granted a provisional license with the previously mentioned conditions.
Thank you. Are there questions? Can I have a motion, please, to accept the staff recommendation? Sorry, do you have a question, Commissioner Todd?
Just a comment, I don't have any financial interest or reason to recuse myself, but just in case it comes up later, before I was a commissioner, I might have made statements that I'm fond of them and how they run their business.
General Counsel, please.
I don't think there's any issue.
Okay, thank you. And your vote?
Yes.
Okay, then can I have a motion, please, to accept or approve the staff recommendation?
So moved.
Can I have a second, please? Let the record show Commissioner Flanagan made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Let the record show the commission unanimously accepted the staff recommendation with respect to ILN 281278. Thank you very much. The next is Alternative Therapy Groups Incorporated, MRN 281255, retailer. Mr. Executive Director.
Thank you, Mr. Chairman. As you indicated, this is an application from Alternative Therapies Group Incorporated. The proposed location is 50 Grove Street in Salem. The license being sought is that of a retailer. This applicant has previously received a retail, cultivation, and product manufacturing provisional license located in Amesbury. The individuals associated with the application are the same as previously indicated: Christopher Edwards, Julio Fuentes, George Christie, and Derek Brock. There are no other entities associated with the application that have direct or indirect authority. The applicant is in fact an RMD priority applicant because they have secured a final certificate of registration for dispensing, cultivation, and processing in Salem. They have a host community agreement that was executed on June 22nd, 2018, and certification has been provided. Actually, I'll correct the previous statement as far as final certificate. The final certificate is for dispensing in the Salem location. The community outreach meeting was held on March 22nd with notice published in the Salem News. There were no objections identified for the commission by Salem. In fact, we received a response on August 2nd stating that the applicant is in compliance with all local ordinances and bylaws. The summary of their plan to positively impact areas of disproportionate impact includes conducting career fairs in Haverhill and Lynn, scheduling and conducting formal interviews with individuals from Haverhill and Lynn, offering job skill assessments and providing guidance for interested parties to receive training relevant to the establishment's positions, continuing to make charitable donations to local nonprofit organizations, and conducting food drives to benefit local food pantries. There were no concerns raised during the background check on individuals or entities associated with the application, as well as no disclosures of any past civil or criminal actions, and no disclosures of any occupational license issues. Similarly, no disclosures of any business interest in other jurisdictions. They have secured their certificate of good standing with the Secretary of the Commonwealth as well as the Department of Revenue. Their plan to become operational is that they are currently an operating an RMD dispensary at this location. They've obtained a special permit to sell adult use marijuana. They claim that they're fully staffed and will be ready to be operational upon the issuance of a final license. The proposed hours of operation are Monday through Sunday, 9 a.m. to 6:45 p.m. They've submitted the required summaries of their policies and procedures. Those summaries have been determined to be substantially compliant with our regulations. Full compliance will be reviewed during our inspection and will be required prior to a final license being issued. The diversity plan includes the following: developing a diverse workforce, an inclusive work environment, supporting domestic violence victims, and lastly, developing a plan to perform staff surveys, analyze the results, identify areas for improvement, and take corrective steps. This is a retail license, so there's no cultivation plant or products to be produced, but the applicant is a vertically integrated R&D and possesses adult use provisional licenses for cultivation and product manufacturing. They plan to supply their own products for retail purposes. The commission staff recommends issuing a provisional license with the following conditions: that the final license is subject to certification that the applicant is in compliance with DPH's regulations. The final license is subject to inspection and audit to ascertain compliance with our regulations. The final license is subject to inspection and audit to ascertain that their facilities are compliant with all applicable state and local codes, bylaws, ordinances, and regulations. The applicant shall cooperate with and provide information to commission staff upon request. And lastly, the provisional license is subject to payment of the appropriate license fee pursuant to our regulations. This recommendation is based on the applicant's demonstrated compliance with the laws and regulations of the Commonwealth and suitability for licensure, and upon the evaluation of the thoroughness of the applicant's responses to the required criteria, we certify that a due diligence review of the application has been performed, and as of this date, they have demonstrated their compliance with the laws and regulations of the Commonwealth and their suitability for licensure, and accordingly, the applicant is recommended for provisional license with the previously mentioned conditions.
Thank you. Other questions? Then, can I have a motion, please, to approve the staff recommendation?
So moved.
And a second, please. Let's show Commissioner Doyle made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Let the show commission unanimously approve the staff recommendation with respect to MRN 281255. Thank you. Next is Cultivate Holdings, number MPN 281305 for product manufacturer. Mr. Executive Director.
Thank you, Mr. Chairman. As you indicated, this is an application from Cultivate Holdings LLC. The proposed address of 1764 Main Street in Leicester. The license being sought is that of a product manufacturer. This applicant has previously secured a provisional license for both retail and cultivation at the Leicester location. Individuals on this application are Stephen Barber, Robert Lally, Samuel Barber, and Adam Sanders as a manager. There are no other entities associated with this application that have direct or indirect authority that have been disclosed. The applicant is an R&D priority applicant, and they've secured a final certificate of registration for dispensing, cultivation, and processing at the Leicester location, and they are proposed co-located with their medical use operations. A host community agreement was executed on April 30th, and certification has been provided. The community outreach meeting was held on March 29th, with notice published in the Worcester Telegram and Gazette. The commission received the response from the municipality on June 20th, stating that the applicant is in compliance with all local ordinances and bylaws. Their plan to positively impact areas of disproportionate impact include direct giving, local sponsorships, and a hiring strategy. There were no concerns raised during the background check on individuals or entities associated with the application, and no disclosure of any past civil or criminal actions, no disclosures of any occupational license issues, and one individual did identify an association with a business in another jurisdiction in both Hawaii and Nevada, but no issues arose with this disclosure. The applicant secured a certificate of good standing from the Secretary of the Commonwealth as well as the Department of Revenue. As far as their operations review, the applicant proposes to be operational immediately upon being granted a final license. The applicant is an existing R&D and has all needed human and capital expenditures to begin operations, and they've already made those accommodations. The proposed hours of operations are Monday through Thursday, 10 a.m. to 7 p.m., Friday through Saturday, 10 a.m. to 8 p.m., and Sunday, 10 a.m. to 5 p.m. The applicant submitted the required plans and procedures. Those summaries have been determined to be substantially compliant with the requirements of our regulations. We will review full compliance during our inspection. It will be required before a final license is issued. As far as their diversity plan, they have a diverse employee hiring strategy. They have internal diversity goals, as well as plans to conduct sensitivity training. This is a production license, so there's no plan of cultivation. However, they do intend to produce gel capsules, sublingual tinctures, balm, edibles, and pre-filled vaporizer cartridges. The commission staff recommends issuing a provisional license with the following conditions: that a final license is subject to certification that the applicant remains in compliance with DPH's regulations. Final license is subject to inspection and audit to ascertain compliance with our regulations. Final license is subject to inspection and audit to ascertain that their facilities are compliant with all applicable state and local codes, bylaws, ordinances, and regulations. That the applicant shall cooperate with and provide information to the commission staff upon request. And the provisional license is subject to the payment of the appropriate license fee pursuant to our regulations. This recommendation is based on the applicant's demonstrated compliance with the laws and regulations of the Commonwealth and suitability for licensure, and upon the evaluation of the thoroughness of the applicant's responses to the required criteria, Commission staff certify that a due diligence review of the application has been performed, and as of this date, the applicant has demonstrated compliance with the laws and regulations of the Commonwealth and its suitability for licensure, and accordingly, the applicant is recommended for a provisional license with the previously mentioned conditions.
Thank you. Are there questions? And can I have a motion, please, to approve the staff recommendation for Cultivate Holdings? Have a second? Let the record show Commissioner Flanagan made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Let the record show the Commission unanimously approved the staff recommendation with respect to NPN 281305. Thank you. The last license application we're going to review is for Northeast Alternatives Incorporated, number MRN 281314, retailer. Mr. Executive Director.
Thank you, Mr. Chairman. As you indicated, this is an application from Northeast Alternatives Incorporated. Proposed address is 999 William S. Canning Boulevard in Fall River, and the license being sought is that of a retailer. The applicant has also applied for a cultivation and product manufacturing license. The individuals identified in the application are Christopher Harkins, Richard Rozier, Kyle Bishop, Zach Cooper, Jeffrey Johnson, Andy Peliquin, and Jared Meehan. There are no other entities other than the applicant that have direct or indirect control or authority over the establishment. This establishment is an RMD priority applicant. They are in compliance with the Department of Public Health, and they intend to be a co-located medical and adult use business in Fall River. They have secured their final certificate for dispensing, cultivation, and processing at that location. The host community agreement was executed on April 13th, and certification has been provided. The community outreach meeting was held on April 13th, with notice being published at least 7 days prior in the Herald News. The Commission received a response from Fall River on August 10th, stating that the applicant is in compliance with all local ordinances and bylaws. Their plan to positively impact areas of disproportionate impact includes hiring a diverse staff that have lived 5 of the last 10 years in an area of disproportionate impact, conducting community service days and hosting charitable events in Fall River, and providing educational seminars in the areas of restorative justice, jail diversion, and workforce development. There are no concerns raised during the background check on individuals or entities associated with the application, and no disclosures of any past civil or criminal actions, or disclosures of any occupational license issues. There are no disclosures of any marijuana-related businesses in other jurisdictions. The applicant has secured a certificate of good standing from the Secretary of the Commonwealth as well as the Department of Revenue. Their plan to be operational for a timeline is that they are a vertically integrated RMD that recently opened its medical use operations to registered patients. The applicant states that it can be operational in the adult use market within 3 months from being issued a provisional license. Their proposed hours of operation are Monday through Friday, 10 a.m. to 6 p.m. The applicant submitted the required plans and procedures and summaries of those plans and procedures, and the summaries have been determined to be substantially compliant with our regulations. Full compliance will be reviewed during our inspections and will be required before a final license is issued. The diversity plan includes the following: hosting career fairs, counseling sessions, and trainings for the benefit of underrepresented and minority communities, developing relationships with organizations serving minorities, women, people of all gender identities and sexual orientations, veterans, and persons with disabilities, with the goal of attracting and hiring a diverse team, and finally measuring their progress of its diversity goals by requiring periodic workforce utilization reports to be conducted by their HR director. This is a retail license, therefore there's no cultivation plan or production plan. However, the applicant is a vertically integrated RMD that is also applying for cultivation and product manufacturing licenses. They acknowledge that they might need to purchase marijuana from other licensees in the short term, however. The Commission recommends issuing a provisional license with the following conditions. Final license is subject to the certification that the applicant remains in compliance with EPH regulations. Final license is subject to the inspection and audit to ascertain compliance with our regulations. Final license is subject to the inspection and audit to ascertain that their facilities are compliant with all applicable state, local codes, bylaws, ordinances, and regulations. The applicant shall cooperate with and provide information to Commission staff upon request, and the provisional license is subject to the payment of the appropriate license fee pursuant to our regulations. This recommendation is based on the applicant's demonstrated compliance with the laws and regulations of the Commonwealth, its suitability for licensure, and upon the evaluation of the thoroughness of the applicant's responses to the required criteria, We certify that a due diligence review of the application has been performed, and as of this date, the applicant has demonstrated compliance with the laws and regulations of the Commonwealth and its suitability for licensure, and accordingly, the applicant is recommended for provisional license with a previously mentioned condition.
Thank you. Other questions? Can I have a motion then to approve the staff recommendation? Let the record show that Commissioner Doyle made the motion to approve, seconded by Commissioner Flanagan. All in favor? Let the record show the commission now sees approve the staff recommendation with respect to MRN 281314. Once again, I just wanted to take the opportunity to thank the staff for their diligence and hard work on the applications that we received today, as well as all the other ones that are in process, so thank you for that. Thank you, Mr. Executive Director. There are no new agenda items that I was not aware of at the time the agenda was published. I would like to just, as a comment to Commissioner McBride, mention that the topic that you raised last time, we will put on the agenda for our next meeting. Are there any other topics that people would like to suggest for subsequent meetings? Commissioner Child?
I just wanted to request that in the licensing updates, if we could get the data that we're already required to track regarding participation in the industry.
Through you, Mr. Chairman, if I may, we absolutely can. In fact, I think the staff has been developing a strategy for doing that, really with an eye toward extracting the appropriate information and just really ensuring its accuracy or making sure we're characterizing it appropriately. But it's something that as a staff we've been endeavoring toward.
Any other items? Okay, our next public meeting will be Thursday, September 6th, 2018 at 1 p.m. It will be back over at the Health Policy Commission. There being no further business for commission, can I ask for a motion to adjourn, please? Can I have a second? All in favor? Let the record show we're unanimously adjourned. Thank you.